Forum 25th Paper Workshop. And today we have with us to discuss a draft paper on a very fascinating topic. It's on Rome Statute, and the paper is titled The Question of Interest of Justice and of Global Battlefield in the Afghanistan Situation at ICC. We have with us the author of the paper, who's Aman Kumar, Assistant Professor, IFIM Law School, Bangalore, India. And to discuss this paper, we have Varaki, lecturer in international law at War Studies Department, King's College, London, as our discussant. Junior Faculty Forum is a paper workshop forum for early law scholars in South Asia to inculcate constructive feedback on research for the early scholars. Our Junior Faculty Forum is an initiative by Professor Tarunabh Khaitan, who, along with Professor Dinesha Samraratne and Professor Swati, are the advisory board members, and Hari Shankar from NLSIU, Diva Prasad from IIM Kozhikode, and along with me are the executive board members. So let us start, and I would request our discussant, Maria, to start with her comments.
Thank you very much. I hope you can hear me well. Good afternoon or good evening, late good afternoon for India, also in Greece. It's 3:30 p.m. here. Thank you very much for the very kind invitation. I'm very honored, to participate in this series, the Junior Faculty Forum. And I'm very also happy to comment, share my thoughts, my problematic actually with the writer of this paper, Professor Aman Kumar, who wrote a paper on the interest of justice and the Afghanistan situation, together with another component, which is the global battlefield, Aman, that you address in this paper. I have to admit that the interest of justice has been very dear to me. It was my PhD thesis, and I wrote that many years ago when nothing had been written on the interest of justice. We had no jurisprudence, we had no theory behind that, and it was a kind of an unknown term within the Rome Statute. It was considered to be a Trojan horse, right? It's an elusive concept in the Rome Statute. And actually, it's a concept that has been kind of demonized by several actors who claim that, oh my God, we have, as I said before, a Trojan horse inside the Rome Statute. And now what about extra legal considerations, prosecutorial discretion, etc.? Well, I'm not here, to give you an outline of this reference, but I'm here to comment on the thought of Aman in his paper. And clearly, he raises some very interesting points and critique in this paper that I would share, Aman, that I share a lot with you. It talks about the Afghanistan situation, which already I wouldn't call it controversial. It's not controversial for us, but it's a situation, that raised issues about alleged war crimes and crimes against humanity that may have been committed also by forces, by people who are not who are residents, who are citizens of a state not party to the Rome Statute. And we have seen also the reaction against this initial opening of investigation. But setting aside that, what was more interesting, and this is the core of Aman's argument, where he starts from, is this infamous, I would say, judgment by the pretrial chamber in 2019, when the prosecutor at that time was a former prosecutor, Fatou Bensouda, who applied for for authorization to open an investigation. Okay, it were under Article 15 and 53. And then the pretrial chamber came with a very surprising judgment for all of us, where basically they say, no, even though there is jurisdiction, admissibility, when we go to Article 53, we have a problem here. And they say, you know, that the investigation, the opening of investigation should actually be in the interest of justice. Now, why is this decision so surprising? First of all, it is surprising because we can say that the pretrial chamber, something that Aman in his paper very much highlights, came with a kind of activism, a kind of judicial activism. But this decision, I would say, was very bad, was characterized as very bad by different set of actors, you know. So basically the pretrial chamber, the judges of the pretrial chamber provided a very confusing decision, offering a new, if you want, interpretation of the interest of justice, mixing too many things, and actually raising issues to the extent of whether they want to limit the prosecutorial discretion and whether they have the right to review the prosecutorial discretion so far based on the Rome Statute and the rules of procedure and evidence. Now, let me say some things. These are things that Aman from the very beginning highlighted, and he spoke for these extremely I would say, non-coherent understanding, you know, of the interest of justice by the pretrial chambers first, linking it, you know, to feasible investigations, to effective investigations, without providing exactly what means an effective investigation at this very early stage, as we know, you know, from preliminary examinations to the stage of opening an investigation. Then even the language the judges used is not coherent. They seem, you know, to mix, to bring new terminology into that. But also, you know, they talked about feasible investigations. They seem, you know, that they take a very different position from the policy paper that the Office of the Prosecutor had already issued in 2007. Okay, so imagine from 2007 up to 2019, I disagree. Aman refers to my position on the policy paper. I disagree. I think it's a very restrictive understanding of the interest of justice on behalf of the OTP, but at least we had a consistent position on behalf of the OTP. You know, what is the interest of justice? And then in 2019, out of the blue, in an extremely politicized situation, such as the one in Afghanistan, the judges come and they say, no. Already there is suspicion about this particular, you know, investigation about the situation in Afghanistan. There is critique. We know that there is this massive critique against the ICC, whether it's a neo-colonial project, a hegemonic project. And in Afghanistan, it's the very first time, it was the first time that we had Western powers actually being, you know, before the court. And then the court comes and it says, yeah, but, you know, it's not, this investigation has to serve the interest of justice. So they made two mistakes. They made many mistakes, you know, they had their legal mistakes there, and their semiotic, symbolic mistakes. The legal mistakes had been summarized by many scholars, whether it's Dapo Akande or David Jacobs or Patrick Labuda, out of my head, you know, or Vasilyev's, Professor Vasilyev's in Amsterdam. And they spoke about the extent, actually, to what extent the judges could actually review at this stage, you know, a request, an application for authorization to open an investigation, which if we take, you know, Article 53, 1C and 2C, and then, you know, paragraph 3, we see, you know, that actually it's only when the prosecutor decides, you know, not to open an investigation, invoking the interest of justice. Okay, so there was a massive debate and critique over there to what extent the judges, you know, could intervene and say at this stage, which is a preliminary stage, that although the prosecutor herself doesn't invoke the interest of justice, still, you know, we take this opportunity, this initiative, and on our own behalf, you know, we decide to do that. Apart from that, this has to do with the review of prosecutorial discretion that triggered lots of debate. And Aman talks about that in his paper. The other thing, that he also emphasizes is the definition, the content they provide, to the interests of justice, linking it, as we say, to the purposes. They make a kind of teleological understanding, to the overall purposes of the International Criminal Court. They talk about effective, as I say before, investigations without elaborating on what they mean about effective investigations or feasible investigations. But then even more, they bring additional factors, that these factors were not in the OTP policy paper from 2007. So they talk about, the fact that there should be evidence, okay? And also, the time, the period between the commission of the crime and the investigation. But more importantly, and this was very much criticized, they talk about the prospect of cooperation. So they make, a claim that actually the interest of justice, analyzing the interest of justice, we should actually take under consideration the prospect, the possibility of cooperation. And Aman in his paper brings the example of Sudan, for example, okay, or of Kenya, I would add, or of other circumstances where we know we may not have cooperation, but still, what is the message that it is conveyed? Okay, so clearly, the critique that Aman in his paper, highlights is a very accurate critique, a critique, that summarizes, I would say, the position of the majority of experts and scholars. I would add also something that I was shocked when I read it, and they make a positive determination about the interests of justice. I mean, it's very clear, that it shouldn't be a positive determination that opening an investigation should be in the interest of justice. Okay, it's very clear from Article 53(1)(c) that it is a negative determination, that despite everything, and there we have the interest of victims, okay, and we have the gravity of the crimes. Notwithstanding that, the prosecutor might decide that that would not be in the interest of justice. So I don't understand it. Actually, I was so surprised by this judgment that I was thinking, oh my God, who are the clerks? I'm sorry to say that, who are the clerks who drafted this judgment, really, because we know it's not the judges, it's the clerks, the legal clerks who draft the majority of the judgments, okay? And why on earth did they come with that? So I was trying to understand, did they try, to respond to this kind of backlash of the court? Did they try to limit the prosecutorial discretion? Did they feel, that this particular, investigation would actually jeopardize the whole project? And issues, that actually they put on the table. They even talk about financial considerations, and budget considerations of the OTP. And my question is that the role of the pretrial chamber to deal, with how the OTP is going to do that? And at the end of the day, even if they want to go there, should they go via the interest of justice? So, Aman, I absolutely agree with your comments, about the interest of justice. You also make a very, you highlight the difference with the appeals chamber and this disconnection between Article 14, okay, Article 15, and Article 53. And how, they decided, actually, they say, no, this is about proprio motu, and this is about state referrals and the UN Security Council, and that the pretrial chamber shouldn't bother at this stage, when we have the proprio motu to deal with that. This is something quite debatable over there, I think the appeals chamber tried to rectify a situation, and maybe to some extent they went a little bit too far. They tried to rectify the mistakes, as I say, of their colleagues, and then they wanted to send a message as well that there is we have prosecutorial discretion within the Rome Statute, and if we have concerns about the prosecutorial discretion, definitely, the interest of justice is not the tool in order to deal with prosecutorial discretion. I want to say that for me, and this is something that I asked before if I could share, I put it on chat. It's a short digital talk post that I wrote, immediately after the first decision judgment by the pretrial chamber. For me, in this post, the main problem, actually, there are many legal problems, there are policy problems, but also I was very much surprised by what I call an unwise, non-wise exercise of judicial review and judicial activism, in the sense, that for me, the judges of the pretrial chamber should know when to intervene, given the timing, of the Afghanistan situation, should consider the overall climate, okay, and then also should consider the interests of the victims, right? And there it was a massive support for the opening of the investigation on behalf of the interests of the victims. So I really believed, that it was an extremely non-wise exercise of judicial review or judicial judgment, together with their decision, to contradict the OTP to that extent, the policy paper of the OTP, okay, and to distance themselves, although I disagree, as I say, with the OTP. It came out of the blue. They came up with their own interpretation out of the blue. That was not wise as well. And also, to deal with the substance of some of their claims, as I say, they were quite shocking. Like, as we say, Aman also highlights in his paper, the focus, they claim, that the interest of justice provision should serve fundamental rights. Of the fundamental rights, and then we have the interest of the victims. So for me, it was an extremely inconsiderate, judgment of their exercise of their judgment, given the fact that there were so many victims in Afghanistan, associations of victims who actually supported the particular application. So somehow, the judges indicated a lack of practical wisdom and understanding of what happens, on the ground, but also the legal and political implications. They made legal mistakes, but also, they put themselves in a discourse that actually exacerbated, if you want, highlighted even further, the critique against the ICC, that it is a political project or a politicized project. And of course, they didn't want to displease, to put it simply like that, the US at that time. It was very clear that it was the US, it was a Trump administration, but between me and you, I don't think that it would be a different response of any other administration, because it had to do, with American armed forces, okay? So that's that's the initial comment, that I can make for the interest of justice at the paper that Aman very well and clearly highlights. The second issue that he highlights is the issue of the global battlefield, and the position, the difference between the OTP and the pretrial chamber and the appeal chamber regarding this nexus, about the territorial component of jurisdiction. And there, Aman actually sheds light on a misunderstanding on behalf of the appeals chamber of the ICRC position of Common Article 3 when it comes to the global battlefield. And in my opinion, that's why I asked you before when you wrote that, I was wondering, I want to ask some questions to you, maybe give me your feedback. Like Afghanistan, there are so many things, that took place in Afghanistan after that judgments, it's the Taliban came back to power, okay? The Western powers we know how they left. There is lots of discussion now to what extent the West should engage in a discourse and a discussion with Afghanistan. The new prosecutor himself, say that he would prioritize the crimes of Taliban as well, against the previous crimes. especially when it comes to women's rights, and other alleged crimes. So from one side, we have this discourse. From the other side, I don't know if you feel that the so-called war on terror discourse, momentum to some extent has faded away. I don't know, whether it was a momentum then, but then we had COVID and somehow, the entire world maybe paused. But also, Afghanistan, if it was not the withdrawal, stopped being, the center of the discourse in the ICC. And then, of course, later we have Ukraine the last year, where if we compare, the speed, because Aman talked about the speed of the Afghanistan situation, the lack of speed compared to the speed with the Bangladesh, Myanmar situation. Okay, so if we think again, if we compare the speed with Ukraine, when the prosecutor himself, with the support of many, many states that submitted referrals, opened, got open an investigation so fast, and then the question was in an ongoing armed conflict. I was wondering, your thoughts about that, whether if you had to write it from the beginning now, if you had to write it now, the interests of justice, and instead of Bangladesh, you would have to compare it maybe to Ukraine, what would be your take? Would it be something different in this regard? And second, how do you see, the so-called war on terror? How do you see, I wouldn't call it the relevance, but to what extent, remains? Because in your paper, I read about the report by the ICRC on contemporary challenges, that it was from 2015. Am I correct, Aman? If I'm correct. And then when we go to 2019, of course, terrorism is there, the contemporary challenges report, but it's different. We talk about urbanization of warfare. We, of course, new technologies and drones, there are issues, who will be always there. But I wonder, whether you see any difference in the discourse and in the momentum again. But having said that, these short comments, I have to say that I really enjoyed reading your paper. It brought memories to me. On the other hand, it was quite interesting. You were mentioning Trump towards the end, President Trump, and the measures against the ICC. And then, who could have thought that we have this withdrawal of the West, and the Taliban would take over again. And then maybe, the situation in Afghanistan, is it a new situation, to put it simply like that. So thank you very much. These are my comments, and I'm looking forward to your ideas as well.
Thank you, Maria, for your detailed comments. And I really liked your take on how legal as well as semiotic defects loaded situation was this. And I think that's a very important point. Maybe that distinction Aman could bring out more beautifully in the paper, that these are the legal defects, only if of course that's the author's call, what to have and what to not have in the paper. But I think that's a very important point that you highlighted. Okay, so Aman, would you like to answer or respond to anyone of those?
Yeah. Thank you so much, Maria. I mean, comments were extremely helpful. I've noted on a few points, which of course will help me in revising the paper again. So to come back to the first question about what if I am to write this paper from scratch right now? So as you notice in the first paragraph, I've sort of ensured that the focus is on Asia. The focus is not on criticizing ICC as being a neo-imperial project or being anti-Africa, but and also not saying that it's anti-Asia, but at the same time saying it. So it's not clearly saying it, but also saying it at the same time that yes, you're not focusing on Asia. Because if you pick up any textbook on, not textbook, but if you pick up any book on criticism for ICC, the biggest criticism is that India and China are not part of ICC. So majority of Asia is not represented at ICC. But then again, you go back and see that, for example, Japan has been contributing so much for trust fund for victim or to the registry. So these debates are still there. And when I was writing that paper was written in the backdrop of Syrian refugee crisis on one hand and Myanmar refugee crisis on one hand. And for some reason, nobody from international criminal law perspective paying attention to Syrian refugee crisis, but a lot of attention was being paid to whatever was happening in Myanmar and Bangladesh, to the extent that ICC started prosecuting. And if you look at the charge sheet which was framed to bring deportation into picture, it itself was a very clever move by the OTP. So it was, when it was written in that backdrop. So I would say, even today, if I'm writing that paper from scratch, maybe because of the ongoing developments, I'll of course talk about Russia. I'll of course talk about the arrest warrant which has been issued. But my focus and attention would still be Asia-centric, because that was the theme of the conference. That was the theme which I have deliberately adopted for the paper, saying that why you're not talking about Asia. And now that we're having this discussion, once I sit down to revise it, I'll even try to emphasize on that point even more. Why? Because now that you have AC's authorization to go ahead with it, what is happening in the Afghanistan situation, nobody knows. Since the new prosecutor has come, I've not heard anything, not even a single sentence regarding the Afghanistan situation. So now that you have the AC's authorization to go ahead with it, what is happening, nobody knows. So after the decision, you've decided, I mean, those countries have decided to go away from Afghanistan. And as you rightly pointed out, the whole discourse about war on terror, or the whole discourse about international criminal law for that matter, has all of a sudden shifted to whatever is happening in Russia and Ukraine. Does it mean that we forget whatever happened in Bangladesh, Myanmar? Does it mean that we forget whatever happened in Afghanistan? Or does it mean that we completely forget whatever happened in Syria? So these are certain pertinent questions which are still there. So in a very weird way, we can still say that again, the focus has shifted back to Europe. So whatever is happening in Europe, whatever is concerning Europe, has again become the concern of international community as far as international criminal law is concerned. So yes, as we discussed before we started, I would want to juxtapose whatever the PTC said there about the feasibility of issuing or starting an investigation. And I'd say that, I mean, for example, what I highlighted in the paper, when the authorization was given, and if we read the OTP's submission, OTP had in fact cited CIA, said that people from CIA are responsible, people from US military are responsible. And surprisingly, there was no mention of the Australian army. Surprisingly, there was no mention of the British army. And in a positive way, the government in Australia and the government in UK are prosecuting or at least investigating these war crimes. But absolutely nothing is going on in America. They are, of course, saying that, yes, we are investigating a few people, but the bottom line is they're doing nothing. In fact, Tony Blair was named in the report in UK, but nothing, nobody has been named in USA. So from that perspective, again, when we see that whatever was done after the decision was given by the appeals chamber, in the sense that you decided to not allow Fatou Bensouda to come to New York, even to attend the regular meetings or represent International Criminal Court at the UN, and compare this with whatever Russia has decided in the aftermath of arrest warrant. Now, Russia has said that now we are going to investigate the prosecutor. So these are two extreme steps taken by two very big powers against the prosecutor of the OTP. So juxtaposing these two situations, of course, I mean, when I sit down to revise this again, these two situations are going to come into picture. But yes, the initial few paragraphs which are there in the paper are going to remain intact, because that shows some sort of frustration which I have vis-a-vis ICC of not paying attention to Asia, whatever might be the reason, but those frustrations are still there. So that's the answer to the first question. The second question is about war on terror. Yes, you're absolutely right when we talk about war on terror, and you rightly pointed out that the discourse has sort of fizzled out after these people went away from Afghanistan. But that also brings into picture one very important aspect, and that is regarding ISIS. And then that goes on to show, and also Syria, and that goes on to show that was it really war on terror, or was it just war on Osama bin Laden? The moment he's done, the moment he's dead, what you wanted to ensure was that you have a government which caters to your needs. And finally, when you realize that they are going to have a lot of internal battles between the elected government and Taliban, you decided to go back. As simple as that, leaving the country as it was. So the point which I've highlighted in the paper is in the context of global battlefield, and that from an academic perspective, that debate remains. That debate remains in the sense that, for example, last year when I'm forgetting the name of that person was killed by a drone attack by USA that army had. Again, it raised the same question. It raised the same question that what is the extent of global battlefield? How are you going to say in the context of ICC's prosecution also, how are you going to determine what is the extent of periphery over which your jurisdiction will extend? Now, in the Afghanistan situation, they are saying that these people were taken from Afghanistan and then put into, for example, a prison in Poland, and then tortured there. Now, these people were taken from Afghanistan in the context of that armed conflict. Hence, there is a relationship because Poland is a party to ICC. So everybody who is there and related to the Afghanistan situation, of course, falls under the ICC jurisdiction. Now, from the perspective of global battlefield, that discourse and that debate still persists. So maybe we have drifted away from the debates on war on terror, and I'll be very happy if there is no war on terror or there is no terror. But the questions which are inherent with the war on terror debate, the questions which are inherent with the concept of global battlefield remain, they remain, and they become even more important and relevant in the context of AI and the context of drones which are there. Yes, to a certain extent, we have stopped using the term war on terror because, again, it was a product of 9/11 and they have avenged 9/11. So that part is done. So maybe we're not talking about war on terror, but the concept of global battlefield, I think, still remains and still debatable in the context of not just in the context of international criminal law, but more importantly in the context of international humanitarian law. So yeah, these were my comments for those 2 points.
Swati, can I ask can I add
Sure.
something? Is that okay? Yeah.
Yes.
No,
sure.
thank you. Thank you very much, Aman, about your comments and your responses. And actually, while you were responding, I took notes, which from one side, it's quite fascinating, isn't that? We know the ICC had no jurisdiction over Syria unless we had a Security Council referral. That was impossible. But we have other justice attempts in Syria with universal jurisdiction. We saw that a lot in Germany and now in other countries. But still, people talk about the ICC. So still, the symbolism of the court is there. And then I was thinking about Asia, and I was wondering, whether Afghanistan or Syria is, broadly speaking, Asia, of course, but then we have Iraq as well, which is another situation, and Palestine. Okay, so we have 3 situations where Palestine opened an investigation. We have not heard nothing. We don't know. Seriously, we don't know. With Afghanistan, there was, before we start, I wanted to check. I have to admit I hadn't checked, and I saw that it was even a request for deferral after the appeals chamber that from the government of Afghanistan, but then with the mess, with the Taliban and everything. So now, they just dismiss the deferral, blah, blah, blah. But again, the prosecutor claimed that, okay, we will prioritize, that was before Ukraine, but they say we will prioritize the Taliban. With Iraq, they closed the investigation at the end of the day. And with Palestine, we have heard nothing. So we have 3 situations, which are either intact or closed or extremely problematic, and I'm not here. I have a very kind of nuanced approach towards the court, in the sense, what is a court? It's not like an overly critique. I take note of that. But seriously, if I were working in the court, and I had to speak in a panel, and they say Iraq, Afghanistan, Palestine, and then you compare other situations, it's Georgia. Now, that they claim that actually they issued an arrest warrant on a Russian guy in Georgia now, for example, for the war in Georgia in 2008, or Syria, or Russia with the arrest warrant against Putin. I mean, there is something there, that has to, that I don't know if it's the Eurocentric, it's a tendency back to Europe, as we say, or something else, but it's not that it doesn't look innocent, to put it simply like that. I mean, it doesn't look innocent. We have about Iraq, Afghanistan, and Palestine, and these are three hot potatoes for any prosecutor, okay? Because I mean, come on, we're lawyers, but we know that the ICC does not operate in a vacuum, okay? And there is massive pressure on the court. So I was wondering, especially for Afghanistan, if we I try to tie it up to the broader context, if any prosecutor would be afraid of acknowledging a kind of the failure of the liberal democracy theme, especially given the idea that the Taliban took over. The Western powers, they had to live like Vietnam, okay? And then again, you try to defend an idea, a project, a myth, an ideology, and then it doesn't look good in very small, in a very plain word. And the second thing I was reading again, I was thinking while you were talking about the global battlefield. And, we have all this whole discussion about the extraterritoriality of application of human rights, okay? And all this hesitation on behalf of states to accept that. And I'm thinking, I was wondering if you see, it's not only about IHL, but it's also this whole humanization of international law, that also has also intervened in ICL. To what extent this global battlefield, which talks about IHL and then subsequently about ICL, it's also a reflection of this whole discourse of how far should this extraterritorial application, and jurisdiction of courts should go. It's something we have seen with the Inter-America Court of Human Rights, with the European Court of Human Rights, and now it goes to the ICC, and which, I just thought of that, but it's something, and we have seen that with drones, as also as an IHL, as a human rights law issue, not only as an IHL issue. So I wonder, again, if this is a kind of, from some judges, it's an attempt to deal with the so-called backlash against courts, if there is a kind of more activism, or if, depending on the panels, you have some judges who feel that they should be the guardians of projects, and they feel that they should, be careful not to upset powers as stakeholders. And then you have some other judges, like the appeals chamber, that, went all the way to the opposite direction, and they just seem not to. So somehow, for me, the problem, maybe this is something I would like to highlight in this discussion, and is the lack. I go back to the lack of wisdom on behalf of the judges. We have seen judges who do not seem to understand what it is at stake. And this is something we see in both issues that you have covered, both the interest of justice and the global battlefield. And to say something, the interest of justice is always there. They always make a consideration on the interest of justice. They just don't name it. If they name it and they say, they know then that the judicial review will kick in, okay? That's why they don't name. That's why I think, for me, it's a tool which is always used, of course, it's always used, but they don't invoke it. Okay. So, yeah, that's some additional thoughts on that. So.
Yeah, that was a very interesting point regarding to what extent we can go in the context of global battlefield. I mean, we will have to rein it in at some point of time, because you cannot just go on and say that in every context will include everything. And I think that's where the core principles of IHL will come into picture. Because when you're talking about, for example, when you're talking about proportionality, those are the things which will come into picture when you talk about extent of global battlefield. So yeah, and I think it's also interesting to see, I mean, maybe 10-20 years down the line, it would be also interesting to see how the personality of the prosecutor or the personal biases of the prosecutor have some sort of impact on the topics and the projects which the ICC is taking on. Because it was very evident that USA was very icked with the last prosecutor, of course, because of the investigation she was starting and the comments she was making. And this one, the current one, maybe, I mean, it was handed to him on a platter by Russia. So it became very easy for him to sort of start his tenure with this sort of war crime. But it would have been interesting because based on my reading of his works till now, he's more concerned with crimes committed against women and crimes committed against children. Because if you look at the arrest warrant which has been issued, it's very clear. I mean, a lot of crimes have been committed in Russia-Ukraine war, but the charges are very specific in the context of transportation of children from one territory to another. That's it. So, and I think he has asked for revisions on the OTP's policy for children also. I think 31st May is the last date for submission of those suggestions also. So he's very concerned. And as you rightly pointed out earlier also, in the context of Afghanistan, again, then it becomes very interesting. Why are you saying that now you'll prioritize crimes committed by Taliban and not by the government? Because if I'm looking at it from the perspective of efficacy, getting people from Taliban for prosecution at ICC is going to be even more difficult, because now they are the government. So on what basis are you going to determine that, okay, these are 3-4 different sets of people, and I'm going to prioritize this particular set? And on what basis? I mean, why not talk about CIA? Why not talk about US Army personnel? Because those were the people, I mean, they were also named in the submissions of the OTP. So why not talk about them also? Why say that we are only going to talk about Taliban? Maybe it's because right now you're noticing the fact that all the policies, I mean, majority of the policies of Taliban are anti-women. So is it because of your biasness that you're talking about that this is what I'm going to target? And there is nothing wrong in saying that. But then my problem is, if you're only going to focus on let's say crimes committed against women, maybe you're going to ignore other serious crimes which are also part of that bracket. I'm not saying these crimes committed against women are not serious or were not serious, but what about other crimes which were also committed and might be more serious in the sense that they resulted in lots and lots of death? So what about those crimes? So again, that's what I said. I mean, maybe a few years down the line, it would be interesting to see, at least do a comparative study of all the first 3 prosecutors of ICC and see what were their individual biasness, what were their individual preferences, and how it resulted in shaping the ICC the way it is. But yeah, I mean, thank you so much for that point about global battlefield. I'll surely look into it.
Thank you, Aman.
Sorry, Swati, last. One more thing, Aman, I just thought, I don't know if you read the Berkeley Human Rights Center, the Law and Technology Hub, they submitted the second communication to the ICC on cyber war crimes in the Ukrainian context. Okay, so you can check it.
I've referred to their work regarding this one, but I've not read it regarding the Ukraine conflict. I'll look into it.
Yeah. So it's the second. So from my understanding, is that they want the prosecutor to choose again. We talk about the expressiveness of international criminal justice, to choose particular behaviors, to convey a message, right? Like the transfer of population of children in particular, or imagine, the Abu Garda in the past, attacking a peacekeeper, or destroying cultural heritage, for example. So they want also, they push that if I don't know the evidence, I don't know, but this communication, that if they have enough evidence, they try to push the prosecutor, the office of the prosecutor, to go down that way on cyber war crimes, which also opens the field of a different understanding of the global battlefield, but still it's within the same meaning, sensibility, of new technologies and of what's going on. So maybe you're right, maybe the global battlefield will stay, but it will take different messages, different concepts, Yeah. Sorry, I stopped.
Thank you so much, Maria, for your comments. Aman, would you like to have any concluding comments?
Not exactly concluding comments, but I would definitely want to thank Maria, because I have said this is my only paper which has been in drafting process for more than 8 months. None of the papers which I've written so far has been in the drafting process for more than 6-7 months, but this has been in the process for more than 2 years now. It has been rejected by 2-3 places already. Maybe now I'll sit back, because what happens is when you write a paper and then it has been so long since you wrote it for the first time, there are a lot of debates which have come into picture. Because, for example, if I've started reading more on global battlefield, and I've realized that since it was written, a lot of new pieces have come up regarding global battlefield, and a lot of people have taken different positions. Not more on IOJ, because IOJ is more or less is not going to come into picture again until unless the ICC again starts talking about it. But the global battlefield question has been discussed. So yeah, thank you so much, because now I have noted a few points which I think is definitely going to help me in in revising this paper, and probably, hopefully, getting it accepted somewhere.
And maybe you can split it in 2 papers. So for me, I would say maybe taking under consideration developments. I don't know, check this Berkeley communication. Maybe you can come, as you say, the global battlefield will stay. But maybe you should, I don't know, maybe you can prioritize. You can write on the global battlefield, because there is focus on that, and provide your own understanding, and maybe about the future and future perspectives. Or you can go back to the situation of Afghanistan as a whole, from the beginning until now, and see how it has progressed. I think that would be very interesting as well, to see, and then split it maybe in periods, chronological periods, or different prosecutors, or the Taliban before and after the regime change, in Afghanistan. So yeah, that could be 2 possible ways, either one phenomenon or the overall situation, and how it has progressed.
So no, the paper as it is now progressing is progressing in 2 parts. So the Asia-centric nature of the paper will become more prominent in the revised draft, because there I am planning to include a few more debates about ICC and Asia. So that part will become more prominent, and the IOJ part will come into will get subsumed there. And because the enormity of the global battlefield debate right now, especially in the context of Russia-Ukraine war, that it certainly looks like that's going to be a separate paper. So yeah, these 2 parts are going to be bifurcated now.
Yes, thank you, Aman, for your comments. We'll now open the floor for our participants and other members for their comments and feedback. So if you have any comments or feedback, please let us know. And I really enjoyed reading this paper, Aman. So one part that I really enjoyed was your transcending from broader questions of IOJ and global battlefield, and then carving out minute questions from that. So it was a transcend from broad to very fine. And I think Maria's point that she highlighted on how far can we discount territoriality on the questions of deciding matters of interest of justice, which you also have pointed out in your paper. And then the other point that you've pointed out in your paper about incongruence on interpretation of IOJ by the OTP, PTC, and appeals chamber. For those questions, I know we have very less literature on interpretation of international law and on international criminal law. But if you could point something, maybe as a reader, I would be interested in seeing one line on that interpretation of maybe in line with the essence of Rome Statute or the mandate of ICC in the text or in the footnote. So, and I think this is a fantastic paper. Yes. So do we have any comments or feedback from? Yes, Aman.
Yeah, just one point. I mean, I also wanted to discuss with Maria. There was a part in the paper. I mean, this draft does not have it because when I was writing it, I was thinking about it and did not have enough time to write it. And since you worked a lot on this topic, I was looking for some literature on legal validity or I mean, what is the legal validity of a policy paper in the sense that I know it's a policy paper. So of course you cannot go in and cite it in that sense, but what is going to be the legal validity of a policy paper? How do you frame it?
Well, thank you. Wow, legal validity. I couldn't legal as an interpretative guidance. It's a guidance, you know. And usually the policy papers are papers that they evolve. As you say now, the current prosecutor wants another policy paper, you know, and actually they had a new policy paper on persecution, on gender persecution. You know, you're right about the priorities. Every prosecutor has different priorities, you know, and it was very clear the first prosecutor was trying to make the court work, operate, have some cases. The second prosecutor was trying to do damage control from the first prosecutor. The third prosecutor has his own agenda in the sense, you know, that he's a former defense lawyer, you know, he knows very well international criminal law. I wouldn't use the word, the terminology of legal validity. I would say that it reflects some guidance, some understandings. What is interesting is that the policy paper on, actually it's the first policy paper of the OTP, the Interests of Justice, you know, 2007, and it hasn't changed. They don't touch it. They don't want to touch it. It's as I say, leave it there. We're not going to ever invoke it publicly, officially, that we are not doing something because we consider that it's against the interests of justice, but leave it there, you know. That's why it came as a shock, the pretrial chamber's initiative to review, to come up with their own understanding, blah, 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 you know. Yeah, it's a guidance of a particular time and of particular people. I don't know if today they would, if they revised it, what they would say. Between you and me, I don't think they would say something different. I don't think they would say something dramatically different because it's very convenient what they say there. So it's very convenient to leave it like that. That's my belief, but maybe maybe I'm wrong. But it's not law. Okay, not law.
It helps that it says OTP's policy paper. It does not say ICC's policy paper.
No, it's OTP's policy paper. That's why it's quite fascinating, actually, this thing with the pretrial chamber. And this is one of the comments I made, that out of the blue, some judges, and I say by judges, I mean clerks. Okay, legal clerks.
Okay, thank you, Maria. So, Rohini, do we have a comment from you?
Very quick one. I am in the British Library, so I'm sorry if there's too much background interference. Maria, it's very good to see you. I hope you're back in the UK. Aman, I didn't have much time to think about your paper. I've just had a day and a half with it. And I think if Maria's already addressed this, then please ignore my comment. But my sense again was that there are two papers here. There's a paper specific to Afghanistan in terms of the trajectory that you want to trace. And then there's a paper on asking the global battlefield questions of jurisdiction, territoriality, the understanding of, what constitutes that sort of territorial breach, and then sort of going back to the basics on international and non-international armed conflict. From what I've seen of your paper so far, I think an Afghanistan specific paper might be more interesting, but obviously it's entirely up to you. In the sense that going back a little into the history and context of Afghanistan itself, and not necessarily locating the conflict at a point where it turns into an IAC or NIAC conventionally, but going back to what the Taliban was, what it used to be, the different trajectories that the Taliban takes, at what point is criminality induced, both in the ICL sense and then sort of the precursor to ICL sense. So I think there's scope to do a lot of interesting work in the paper. And then there are substantive, conflict feminism debates around what is happening in Afghanistan, which also I think in the context of the paper that you're writing might be very interesting. The way I understand this through process, or rather the process value of the question you're asking, are actually very critical in nature. So for me, again, this is very much a 12 paper asking 12 questions, but doing it through the process value of ICC and so on and so forth. So again, entirely up to you if you want to have that conversation in that particular way, but I see a lot of critical potential in the question that you're asking, focusing on the processual nature of the ICC. So really enjoyed reading it. And I think perhaps if you were to think about turning Afghanistan into the, the focus of the conversation and using that to unpack whatever it is that you're unpacking vis-a-vis our questions of IOJ would be really interesting. But sorry, I tuned in late. It was hard to find a quiet place, but thank you.
Yes, thank you, Rohini. Thank you so much. Do we have any other comments from any of our participants today? Yes, Aman.
Yeah, no, just wanted to say thanks to Rohini, because this 12 argument was very interesting, because as I said, this paper has been sent to so many people, and one of the colleagues is also working on 12, and she sort of suggested that why not make it more doctrinal, in the sense why not adopt 12 and then start looking at these questions. Because if you look at it right now, it simply says this is what is the understanding of this article, this is what is the understanding of this article, this is how it is to be interpreted. And so far, all my works on international criminal law has been from that perspective, where I take some sort of some judgment by ICC and say that this is how it should have been interpreted. So I'm still not very, very sure if I am capable enough to convert it into a 12 paper from as opposed to an ICL paper, but yes, I'll definitely look into it now that it was only when I submitted it for this JFF, and afterwards when I started reworking on this, that's when I decided that I'll now divide it into two parts. So yeah, definitely I'll start looking at it from that 12 perspective also, to see if I can actually do justice to that argument. So thank you so much.
Yes. So quickly, one point on what Rohini said and what you responded. So when I read this paper for the first time, my first take was that, yes, you have put out blatant problems with what PTC, OTP and AC has done. But then maybe this is an inherent problem with Global South scholars, that you have not said with vehemence what is there in your heart. So maybe concluding lines on whatever your blatant findings are, you need one. I hope I made my point clear on that.
Yeah, so all my anger got fizzled out after the first 2 paragraphs of the paper. That's it.
Yes, maybe that. Okay. Do we have any other comments? Okay, then thank you so much, Maria, for taking out time and for sharing with us such detailed comments. And thank you, Aman, for considering Junior Faculty Forum as a platform to share your draft paper. I thank all the participants who've joined us today, and we'll soon share the details of the upcoming JFF workshop. Thank you so much.
Thank you. Thank you, Aman. Thank you for the invitation. And it's very good to see Rohini, Rohini in London soon. And thank you very much. I'm looking forward, Aman, to the next version, of the paper. Thank you all very much. Thank you.
Thank you so much for your comments.
Thank you.
Bye-bye.
Thank you, Swati, for organizing.
Thank you, Aman. Thank you, everyone.
Bye.
Bye-bye.